Hey guys, it's Kathy. I hope you're doing well. So before I get started, I just want to go back to the video that I made when I spoke about nurses and how nurses are heroes and everything. I got so many comments on that video on how nurses are heroes. So if you're a nurse, you should read some of the comments because they're really good. They're really good, and we thank you. Doctor, parent, uh, any type of caregiver, I should say. So, all right, I have a problem, and you guys can help me fix it. I have a seriously long to-do list. I have a lot of things I need to get done that I have not been getting done. So here's what I thought I would do. For every 1,000 members I get during this stream, I'll take one thing off of my to-do list. I'll do it. Yeah. And if I don't get 1,000 members this stream, then that just means I can sleep on Monday. So that's it. That's what we're going to do. We're going to decide what my Monday is during this stream. I'm either going to take things off of my to-do list or I'm going to sleep. It's up to you guys what I do. Here, I'll just so you know, I'm not just trying to get out of work. I'm not just trying to get out of work. I'm going to help my plan succeed a little bit. There we go. Now it'll work. Good job, Kat. Now you can see the members only videos. Alright, we're going to start in Arizona because they got a new background and I can't help it. It's hilarious to me. This new background is hilarious. So we're going to start there.
God, she's been so good. I know.
So what were the two names?
Nancy Price and Kathy Reese.
So we'll say no Nancy and Kathy?
Yes.
We live in the same park.
Yes.
Okay.
We're about all together.
Okay.
She's been so good too. It's sad. She made the wrong
Hi there, can you state your name, please? All right, is your middle name Ann?
Correct.
Okay, and you live on number 19?
Correct.
Do you have an email address?
Yes.
It indicates on the booking paperwork that you refuse to provide that and your phone number. Is there a reason for that?
No.
Okay,
Great.
all right, I'll collect it now, go ahead.
Hey, 928.
Thank you, JK.
Okay.
Thank you.
Wait, 928. Hang on. 928 595. I just changed it.
All right, and how about your email?
Email is, I can't remember that one. LATOOTS, Mature.
Thank you. The state is alleging one felony and then 1, 2, 3 misdemeanors. The felony charge is aggravated driving under the influence of alcohol. That's a class 4 felony. You have the right to remain silent, right to counsel, and right to trial. I scheduled you on that felony for a preliminary hearing on the 20th of March at 4:00 p.m. Preliminary hearing is where the state prosecutor or state representative will present testimony and evidence to a judge or to a grand jury.
All I wanted the two deputies to walk behind her, like walk like an Egyptian or something.
To determine if there's probable cause to charge you with that aggravated DUI. If there is probable cause, the case will be transferred to the Gila County Superior Court, and they'll take disposition on the case. If there's not probable cause found, then the case will either be reduced or dismissed. Your release conditions for all of the charges are obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court. Do not possess or consume any alcohol or drugs without a valid prescription. So you are now prohibited from possessing any alcohol or drugs without a prescription.
They're using MS Paint to make me happy because it made me so happy watching him.
Do not use any firearms. Since this is a felony allegation, you're not allowed to possess firearms, and if you're convicted, you could become a prohibited possessor. Regarding the misdemeanor charges, you have 3 charges. One of them is an open container of alcohol in the vehicle violation. That's a class 2 misdemeanor. And 2, failure to comply with the court order. Those were when they attempted to get your blood and you resisted and fought to stop that from occurring. Those are class 1 misdemeanors that you have the right to remain silent, right to counsel, and right to trial on. On that one, I've scheduled you for an arraignment on the 19th of March, so one day before the other one, at 8:45 a.m. That's where you'll need to be prepared to plead either guilty, not guilty, or no contest to those misdemeanor violations. Depending on how you plead will be what happens next with the court proceeding on the misdemeanors. And all of those options will be explained to you prior to giving your plea, as well as the penalty range for those violations. Your release condition that's different than the other one, there actually isn't any. It's obeying all orders of the court, not to commit any crimes, notify the court of any address change, and not to leave the state of Arizona, and again, not to possess or consume any alcohol or drugs without a valid prescription. Now, on the felony charge, I'm placing a $2,500 bond hold. You'll remain in custody unless you post that bond. And on the misdemeanors, a $500 bond. So a total of $3,000 is the bond. They are bail bonds eligible, but that will be the total. And since you're held in custody on a felony charge, you have the right to a court-appointed attorney if you cannot afford to hire one. Can you afford to hire your own attorney?
I don't know. I'd have to look to see what the attorneys are for right now, because right now I don't, but I don't know if I...
All right, so let me, if you don't mind, what I'll do is ask you some questions regarding your financial information. And that determination will at least qualify you or not for that court-appointed attorney. Give me one moment.
I wish we had body cam because she was definitely a Karen.
All right, so, all right. First off, I need to administer an oath to you swearing to the financial information. If you'd raise your right hand. You solemnly swear the information you're providing in the court regarding your finances will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God. Yes, I do.
All right. What is your marital status? Single, married, partnered, separated, or divorced?
He's fallen. He's passed away.
Okay, so you're single?
Yes.
How many other people do you financially support?
Just myself.
Okay. Do you have a job?
No. I get,
Picture
my, social, not social security,
Disability?
no, retirement for my husband.
Okay. So I'll ask you about that in a moment. Right now, what is your monthly take-home pay, including your retirement from your husband, and any other sources, meaning any income?
$3,000.
Okay. Do you receive income from any other sources like Social Security, disability, unemployment, child or spousal
Social
support?
Security.
All right. And is that amount included in the top amount you already provided?
No.
Okay. How much is the Social Security?
2,000.
Do you collect any food stamps or anything?
No.
Okay. Do you own a house?
No.
Do you have any bank or retirement accounts?
That's, my bank account is for Good Chase, and that's what all that other stuff goes into.
So you do have a bank account.
Yes.
All right. How much funds are in the bank right now?
I'm guessing 13,000, I'm thinking, because of getting my social security, my checking account, has more in there.
Okay.
And my savings has more in there than my checking account does.
Okay. But in the combination of that, it's 13,000?
It should be 13,000.
Okay. Do you have any outstanding loans?
No.
Do you have, what are your monthly expenses?
About $1,400 a month.
Yeah, so monthly you have roughly 5,000, so $4,500 or $3,500 of extra money after your bills?
Yes, but that's for my insurance and everything else. My medical, I have to pay for my medical.
Okay, so that $1,400, does that encompass your medical?
Yeah, that's comes out of that 1,400.
Okay, so your monthly expenses total $1,400.
The actual jail thought this would be a good court background. This is what they picked.
Correct?
Right.
So my question to you is, you have a total of income of $5,000. The retirement plus the Social Security is $5,000. You only take out of that $1,400 and the rest is surplus.
Correct.
Okay.
Well, I support my daughter in Connecticut. I send her money, so.
Is that, but she's an adult?
Yes, she is.
Okay, so you're choosing to do that.
Correct.
Okay, all right. It doesn't look like you are going to qualify for a court-appointed attorney based on the income value. Okay, so at this point, unless that changes, the court-appointed attorney is going to be denied because of the income. You have too much money left over after your bills. So now on the misdemeanor charges, since you're held in custody on that charge as well, those charges, excuse me. That you have a court-appointed attorney assigned only to a bond review. Being that you're held on bond, they're only going to be appointed to your case to review the bond. If they find that the bond is not necessary or whatever, they'll request a hearing and notify you. But if they find that the bond is reasonable, then they'll leave it in place. So it's not for the whole case, it's only the bond. Do you understand that?
Not really. I went bypass that.
Yeah, so let me explain it to you again. So you have, think of it in two different things. You have misdemeanors on one hand and a felony on.
Could you draw? Could you draw what you're talking about? Could you make like a misdemeanor column? Please, Judge.
The other. So on the misdemeanors, you're held on a $500 bond. You have an attorney assigned to that case, but he's only for a bond review. He's not for the entire case. Okay, so he's going to be notified that you're held with a misdemeanor with a bond. He's going to look at that and look at the charges, and if the attorney requests a hearing, we'll have a hearing regarding that bond, and he can say what he chooses to. If he finds that the bond is necessary and reasonable, there will not be a request of a hearing, and that will conclude his work for that case because it's only a bond review. Any defendant that is held on a misdemeanor is assigned an attorney for the bond purposes only. Okay?
Okay.
All right. Does that make sense now?
Yes, it does.
And then on the other one, the felony, you have the right to a court-appointed attorney, but your income doesn't support it, so that the right does not exist for you because you have too much income.
Okay.
All right. So your total bond again is $3,000. And just so you're aware, Nancy and Kathy, your neighbors, are here and they're hearing what's taking place.
Okay.
All right? Yeah.
Yeah. Her neighbors had to know what was going on. Her neighbors came to her court hearing.
Have any questions about any of the information
Hi,
we talked
Maria.
about?
No, if I pay that 3,000, then, how would I do that for my checking account? Because I have a private client card. Would I just run it like I normally would at a store here, and then put my PIN in, and then it would...
I don't know how you'll do that, but what I can tell you is the detention staff can help you make arrangements. Kathy and Nancy, if you need to ask them to do something for you, you can do that. They can come down to the jail cell and see you. I believe you will be transported to Globe, so if you are planning on bonding out, make sure the detention staff knows that.
Kathy and Nancy currently want to see your manager right now, though, Judge.
So they can do that before you're transported.
Okay, could we do that before I'm transported, then I can
Yeah.
say, okay, I can do that.
All you need to do is discuss it with them and they'll help you walk through the steps.
Okay, so my bank's right across the street.
Any other questions?
No, thank you.
I'll get with you. Yeah. All right. That'll be all then. Have a good day.
Okay, one thing, after I'm bonded out, I can use the telephone, right, to call Nancy or Kathy to come pick me up?
Well, I'm going to give them directions to go down there if you're planning on bonding out. That way they can talk to you and talk to the detention staff as long as it's visiting hours.
Okay, but I'm not
Well, here's what I might, Judge, can you just tell them to come to the jail and I will talk to them when they get here?
I will.
Okay, that.
Yep, no problem. Yep.
All right, thank
All
you, sir.
right. So I'll direct them to go down there and hopefully they will.
Okay,
Yeah, they don't have to, but I'll tell them to and they can hear what's going on.
We are. We will.
okay, thank
Okay.
you.
All right, you bet. Bye. They said they are.
Okay.
Welcome to, welcome to the most professional court in courtums, in all of courtums. Hi, Tammy. The cop that was disappearing, or the older cop that uses this every day. Oh gosh. Okay. All right, let's go. Let's go to a professional courtroom, please.
Mr. Van Boxel, you're here for arraignment on a 3 warrant. Do you understand that?
On a what?
3-count probation violation warrant. Do you understand?
I can't, because I would have only drew one thing over and over and over again, and it would have been inappropriate.
And that, sir?
Yes, sir.
All right. Did you receive a copy of that requested warrant for probation violation?
Yes, sir. I just don't understand why I gotta go through this now when I'm not even found guilty yet.
Well, I'll walk you through the process. So did you receive the document, sir?
Yes, sir.
Did you read it?
Yes, sir.
Did you go over it with Ms. Ulicki?
Yes, sir.
All right. Did you also receive a copy of your probation violation arraignment advice of rights form?
Yes, I did.
Did you read that document?
Yes, I did.
Understand those rights?
Yes, for the most part.
Is there something that you want me to explain to you about that?
No, not really.
All right. So the allegations here are that you were placed on probation for assault with a dangerous weapon, habitual offender third. That's a felony which carries up to 8 years in prison. Do you understand that?
Yes, sir.
You are alleged to have violated your probation. You've got, looks like you got 2 technical violations and 1 non-technical violation. Count 1 says that you violated condition number 2.4, which prohibits you from using or possessing controlled substances. And the allegation is that on or about March 8, 2025, that you were found in possession of marijuana. Do you understand the allegations contained in count 1?
Yes, I do.
All right, count 2 is a non-technical violation. It alleges that you violated condition number 1 that prohibits you from violating Michigan state law The allegation is that on or about March 8, 2025, you violated state law when you were in possession of methamphetamine. Do you understand the allegations contained in count 2?
Yes, ma'am, or yes, sir.
All right, count 3, another violation of 2.4, when on or about March 8, 2025, you were found in possession of methamphetamine. Do you understand the
2
allegations?
charges.
Certain conduct can violate more than one condition of your probation.
Okay.
So the allegations raised in count 3.
What's
Mr.
that?
Van Box, do you understand the allegation raised in count 3?
Yes.
All right. And Ms. Ulicki, what plea does you wish to enter?
You're muted.
You need to unmute your device.
This lawyer is special, guys. Hi, Bobby.
Yes, Your Honor. My client wishes to enter a not guilty plea to this probation violation. He is requesting that a hearing be conducted within 14 days of today. He's also requesting that the court appoint him an attorney to represent him at that contested hearing. And he is also requesting personal recognizance bond in this matter. I understand that he has a job at Magna where he has been working for the past 6 months. He has not missed any of his days for work. There has been no disturbances at work, so he is not facing any kind of issues regarding being a safety to himself or the public. I understand from him that he has shown up for all previous court.
What in God's name is that? What is that? Does anybody? And that actually, what is this stuff? I missed it the first time. That looks like a black sheet. That looks like a board. But what? What is that thing? You know what? No.
Hearings, and I understand that he has also shown up for meetings with his probation officer as required, and therefore we're requesting the court to grant him a personal recognizance bond so that he can go to work. They did let him have today off to come to this hearing, but he does have to return to work if he intends to keep his job, and he does work full-time from 8 till 4, and I understand he makes $15 per hour and has the usual expenses of car insurance, car insurance, and normal expenses that go with raising a child in the household as well.
All right. And Ms. Robinson, anything that you want the court to consider as far as the bond goes?
Poltergeist. She looks like a female version of the preacher? The pastor?
Your Honor, I don't believe a PR bond is appropriate in this case. After speaking with the agent, apparently Mr. Van Boxel has signed 5 PV waivers up to this point in the past, I think approximately a year that he's been out. One of them was for some sort of either failing to report police contact or driving. The other 4 were for positive meth tests. So he has tested positive for methamphetamine 4 times during the course of his probation. Now he has been caught with methamphetamine. He has been charged with that possession by our office. That happened this morning. I'm not sure if he has been arraigned on that. I know the officer was here right before noon, so I don't know if that has occurred yet. But it's clear to me that even though he has been doing all of these other things based on the fact that he has had 4 previous positive meth tests, he is continuing to use methamphetamine. and that is not stopping. He was offered inpatient treatment when that happened after one of the tests, and it's my understanding that he did not wish to avail himself to that, and now he has been caught. So possession of methamphetamine is a serious felony charge. The continued use does present a danger to himself as well as the community at large, and we would ask that the court take that into consideration in setting a bond.
All right, the court is going to deny the request for personal recognizance bond. The court said bond $15,000 cash or surety. The defendant had failed to report as instructed to probation back in July. There's multiple counts of that. He said, I have 4 prior technical acknowledgments, including the use of controlled substance, including other violations of the law. Certainly, this is the most serious allegation of violating the law. So the court is going to set a bond at $15,000 cash or surety. Because this conduct that's part of this probation violation is the subject of new charges, the court is not going to set this case for a probation violation hearing within 14 days. The hearing will be set for April 21st. It will be set for April 21st at 1:50. The MIDC would appoint John Greer to represent him in this case. That's all for today.
Thank you, Your Honor.
Is that, hey, excuse me, Your Honor, is that 15,000, is that 10%?
No, sir, it's cash or surety.
He has a lot of problems, guys. He has a lot of problems. I'm not showing that. Okay. So this one is scary. This one is scary. I talked about it yesterday and I got it today.
Can take a break, or I can stay in here if it's well, I don't know if I should. It's just the two of you. Okay, I can't stay in here while they move everyone around, but then we can get Honholt and
I'm going to take Bozeman too.
Ford. Take
Edward Bozeman's the plea. We could also do him too. I think did I email about him? No.
I have an email from you about Rogers. I want to do Rogers, and then we can.
No, for every 1,000 members I get tonight, I'm taking something off of my to-do list. I'm going to get something done that I've been putting off. Yep.
Get people up. Mr. Luemba, we don't have forever. Hopefully he's coming back. He needs to talk with Ms. Ford.
Yes.
Step up.
Cell phone rang.
A cool ringer though. So let's do Mr. Rogers, and then we can take stock. I know we got a couple. We got Mr. Holliday sitting out there, and we'll figure out what we need.
Oh, can he sit down? Oh, yeah.
Rogers?
Yeah, he doesn't have.
Sure. No, as long as that's all right with the deputies. I'm good with that.
Hey, Kay, I'm shocked that you would say that.
Hey, Mr. Rogers, we're gonna have you sit right there, please.
I watched that Stevens clip, Kelly. It was really good.
Can you, Ms. Rios, rotate the camera a little bit so it gets Mr. Rogers? Thank you.
Okay, what he did is crazy
And
and scary, but crazy. I'm gonna get down.
Ms. Dilligard, you ready?
Yes, Judge.
This is 24 SC 00440.
I was muted. Yeah, that happened. This necklace is really bright green, like my green screen behind me. But it erases, this camera erases all yellow. But this is a St. Patrick's Day necklace. There's little shamrocks on it.
6, State versus Derek Rogers. Good morning, Mr. Rogers. Ms. Rios tells me you are ready to enter a plea in your case. Is that right? Okay. Ms. Dilligard is going to put you under oath in just a moment, ask you a bunch of questions. You need to answer those truthfully and completely. And please let me know if you've got any questions of your own, all right? And make sure you speak up when you're answering. Ms. Rivers needs to be able to hear you. I'm having trouble, so she may have trouble. When you're ready, Ms. Dilligard.
Mr. Rogers, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can lower your hand. Please state your true, correct, and legal name for the record.
What is your name?
Derek Rogers.
Mr. Rogers, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
45, some college.
Mr. Rogers, do you understand that you've been charged with the following offenses? It's 1 count of kidnapping, a count of false imprisonment, hijacking a motor vehicle in the 1st degree, possession of a firearm during commission of a felony, and theft of services.
Yes.
The mute button sucks a lot.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances relating to these charges?
Yes.
Would you like more time to discuss the case with your lawyer?
I'll show you.
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Rogers, do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum maximum sentence for each charge which you're pleading guilty to today?
Yes.
Sorry, I'm just going to run through the ranges with you. For the false imprisonment, the range is 1 to 10. I skipped the kidnapping. Kidnapping, the range is 10 to 20. For false imprisonment, it's 1 to 10. Hijacking a motor vehicle in the 1st degree is 10 to 20. Possession of firearm during the commission of certain felonies is 5 years consecutive. And for theft of services is 12 months.
Do you understand those are the ranges for those crimes? Great.
Yes, he did. He kidnapped him.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to no pros the kidnapping count 1, and to plead to the rest of the indictment, it's 10 years probation. We're going to reduce the hijacking of a motor vehicle to the 2nd degree, which has a range of 1 to 10.
Okay.
The conditions of probation is 110 hours of community service, no utilizing any rideshare services, i.e. Uber or Lyft, and no contact with the victim.
How'd you get 110?
Negotiations. We came off with something, so I added a little bit, Judge.
Okay.
Is that your understanding of the recommendation, Mr. Rogers?
Can you speak that again?
Is that your understanding of the state's recommendation?
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges which you are pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Do you understand that the court decides to enter a sentence that differs, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Under the Alfred law.
Okay, I think you had flagged that in email. This is a plea being tendered under North Carolina versus Alford?
Yes, Judge.
Okay, got it.
So are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, my best interest.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Mr. Rogers, how do you plead to the charge of false imprisonment, hijacking a motor vehicle in the second degree, possession of a firearm during the commission of a felony, and theft of services in indictment number 24 SC 004406?
Guilty under the Alfred law.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes.
Kelly, rude. No, I don't.
Judge, if this case were to proceed to trial, the state contends that the facts would show that on January 3rd of 2024, the victim in this case, Oscar Perez Salcedo, Salcedo, received a request from the Lyft application to pick up this defendant at the from the Martyr Manziel Road parking lot. He said that when the defendant approached the vehicle, he immediately told the victim to turn off the Lyft application while presenting a firearm, brandishing his firearm at that time, and told the victim to drive to Tupelo, Mississippi. They began driving and they made some stops in Alabama.
He made him drive a couple states away.
They made a stop at a liquor store. They made a stop at a food mart. They made a stop where the defendant engaged in a drug transaction, and then they made a stop at the cigar lounge. It was at the cigar lounge where the victim was able to get away from the defendant, go back to his car, and flee. The defendant then came back to Atlanta the next day went to report the crime. He had to go to a few different locations. First, he went to Marta, and then they told him to go to Roswell. Then Roswell told him to go to Alpharetta. He also is not English speaking. So he had some difficulty reporting the crime. So the crime initiated here in Fulton County, Georgia. I have met with this victim multiple times. He is comfortable with the resolution. He does not want this defendant to ever be able to do this again to someone, and hopes that he learns from this. He does want the court to know that at that time, he was very afraid for his life, and he's afraid for, and that's where the stipulation or the condition of not utilizing rideshare services comes into play. And that was one that was requested from the victim as well. Judge, there were a few concerns in the case, and that's why we resolved it in this matter. There were multiple locations that the defendant took the victim prior to him actually fleeing, and so there were some questions regarding.
Why didn't you drive away when Mr. Rogers went in the liquor store or
Judge,
whatever? And
as you can see, this defendant has some physical impairments as well, and so that is the recommendation of the state. We ask the court to accept.
Okay. But importantly, you've been speaking with Mr. Salcedo. He's aware of this, and his main focus is leave me alone and leave other Lyft and Uber drivers alone.
Yes, Judge. And I will add that he, in our last meeting together, stated that he has not been able to go back to doing rideshare services because of the trauma that happened here.
All right. Thank you for sharing that. Ms. Jackson, do you have any criminal history information on Mr. Rogers?
Yes, Your Honor. He has 38 cycles. The last arrest was April the 6th, 2024 in Brookhaven, Georgia, for aggravated assault and possession of marijuana less than an ounce, and possession of Schedule I controlled substance, and possession of a firearm during commission of a felony. There was no disposition for that arrest. Also, he appears to have an outstanding hold out of Griffin, Georgia, for a failure to appear. The date on that warrant was June the 21st, 2023. The underlying charge was not listed. He does have misdemeanor convictions and sentences. One in 2022 out of Cobb County for obstruction of an officer. One in 2021 out of Byron, Georgia, for driving while license suspended or revoked. He received a nolo contendere sentence in 2019 for theft by shoplifting. There was a conviction in 2019 for possession of marijuana less than an ounce. And there was an additional conviction in 2019 out of Dunwoody, Georgia, for theft by shoplifting. And there was a conviction in 2017 for 2 counts of simple battery. And he has a misdemeanor conviction in 2016 out of South Carolina for driving without a valid license and unlawful U-turn. Nothing in addition, Your Honor.
Thank you. Ms. Rio.
I hate when people U-turn when they're not supposed to. Lock him up.
Yes, Your Honor. Mr. Rogers is 45 years old. He's currently receiving disability in 2019 was in a severe car crash, which took his leg. So he is currently receiving disability for that. He has 3 children, ages 21, 24, and 2 years old, and also grandchildren, ages 2, 4, and 9. He currently, when he gets released, he'll be living with his mother in Atlanta, Georgia. Like Ms. Dilligardi said, we had a lot of back and forth discussions because there were some issues with the case that to me did not make complete sense. He's maintaining his innocence. He has a total different version of what happened that day. But he does want to be out so he can be there for his family, and he doesn't lose his disability. He did attend college some college at Lincoln College of Technology. We are also asking for a behavioral incentive date. If he has nothing in of the 5 years on probation, if it can be terminated early.
What do you know about the DeKalb County aggravated assault case? I don't mean the facts behind it, but is that open? What's happening?
I am not sure.
It's still unindicted. Okay. Anything about the hold from Griffin?
I believe he said that was a traffic offense that he missed for traffic.
But you think there's still a hold for that?
Yes, there is. I'm pretty sure that hold is still there.
Okay.
So he wouldn't be released. I've already explained that he wouldn't be released to the street.
Got it. Mr. Rogers, what is your version of events?
He's taking an Alfred deal, which means he's not pleading guilty, or he is pleading guilty because it's in his best interest, but he doesn't agree.
How did this come to pass?
Well, I ordered a Lyft ride on the 3rd of January. And when I got
To go where, like when you punched it in, like,
I punched it in to go to Jasper, Alabama.
oh, so this was a serious lift ride. You put it out there, I'm going to Alabama. It's a long ride.
Right, $240, they charged my card. When I got there, he seen how much the Lyft ride was gonna be. He said that he'd rather do it for cash. So he was trying to backdoor Lyft and make all the money himself. And so at some point during the trip, I don't know why he figured, he should leave me, but he threw my bags out the car. There was never a gun pointed at him, threatened him, or anything like that of that nature. So, I mean, I'm just really like tired of being in this jail. There's lots of stuff going on in there, and I think it's just the best route for me to go right now.
Where did you get thrown out of the car? I mean, I know he didn't throw you out. He threw your stuff out, so you had to get out. Where was that?
That was in Birmingham, Alabama.
So he got you to Alabama, but not to Jasper.
Not to Jasper.
How far is Jasper from Birmingham?
45 minutes.
How'd you get the rest of the way?
Caught another Uber to the Greyhound bus station in Birmingham, and I Greyhound onto Tupelo.
But Tupelo and Jasper are different.
Right.
Why'd you go to Tupelo instead of Jasper?
I mean, that was the place that I was going to go, but I only had a limited amount of money on my card, so I had to go that far on Lyft.
Got it. You figured, hey, I can make it to Jasper. They're going to hit me for $240. That'll get me to Jasper. That's as close as I can get. And then you were going to figure out a plan from there.
Right.
What's in Tupelo?
Well, Tupelo, I got family there, all throughout Northeast Mississippi. So I was born in Monroe County. Okay. I'm just a Mississippi native.
Got it. But you'll be staying in Georgia.
Yes.
All right. Anything you want to add?
I wish this would go away. I wish I didn't have to commit to this 10-year probation. But like I said, I feel like this is the best thing that I should do right now. And so I'm going ahead with these pleas under the Alford law.
Okay. You understand an Alford plea is when a defendant says, I don't agree with everything the state says. It sounds like you agree with some of it. Yeah, I rode in the car with this guy, but you've helped me understand where the stories diverge.
Right.
But you're also saying it's in my best interest, meaning Mr. Rogers' best interest, just to wrap this up. I know I could go to trial. I don't want to run the risk. Mr. Salcedo comes in here. They believe him. They don't believe me. I got this criminal history, and the jury may find me guilty. And dang, I'm looking at 10 years to serve on the kidnapping. And so you've decided, after consulting with Ms. Rios and others, that it's in your best interest to go forward with the plea that Ms. Rios has been able to negotiate for you.
Yes, sir.
Okay. All right. I'll accept it as an Alford plea. I find there is a factual basis for your plea and that your plea is knowing and voluntary. You clearly understand what we're doing. And I do think it's voluntary. You told me you're not thrilled about it, but this is actually how you want to work it out. You don't want to wait another month for a trial or this or that. You want to resolve it this way. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you are on probation, which will be for a while, if you have a minor violation, you and probation work through that. You don't have to come see me. If you are arrested again for anything, that comes back to me. Any arrest, I'll be dealing with whatever consequences there should be. Do you have a weapons carry license?
No.
All right. Ms. Dilligard, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Rios?
Yes, sir.
Mr. Rogers, is it okay if we sign your name to the Alford plea on the indictment?
Yes.
We'll do that. I am going to sentence you on count 1 to nothing because that's been dismissed. Count 2, I'm sentencing you to 5 years to serve 9 months with the balance probated. Count 3 is 5 years to serve 9 months with the balance probated. That's running concurrently with count 2. Count 4 is 5 years consecutive to count 2. That is probated. And the final count is 9 months to serve. That runs concurrently with count 2. You'll get credit for the time you have served. You'll be on probation for 9 years and 3 months. Special condition of probation number 1, no contact with Mr. Salcedo. I know he's a stranger to you, but he's findable. Don't find him. No ride shares for you. I know that's complicated. It sounds like you're not doing a lot of driving yourself, but while you are on probation, no Lyft, no Uber. You get a ride with Fred or Jane or Marta, but no ride share. And you'll need to complete 110 hours of community service. I encourage you to find a place where that works for you. You just raised your hand. Yeah.
How do you do community service in my condition?
So a lot of people, when they think community service, that's walking along the highway and picking up trash. And that's what it is if you aren't real engaged in the process. I don't know your family connections or friends or whatnot, but you could work in a soup kitchen where you're serving food or you're doing this or that. As long as it's volunteer work, you're not getting paid and you're not volunteering for a car detail shop where basically you're helping a buddy make money, but it is actually volunteer work and it's documented. So the folks who run the soup kitchen at a church or whatnot, they're able to sign a piece of paper that says, hey, Mr. Rogers was here for 5 hours today. That's community service. Okay. And probation will roll with that. You need to talk to your probation officer, but he or she will say,
I don't know. They should be able to talk on their own behalf at some point before sentencing. So he's pleading right now. He'll probably get allocution when he's at sentencing, but he is at sentencing, so I don't know. I have no idea.
I got 10 other ideas because they'll see you and say, no, what you can't be doing is climbing up in trees and getting trash out of trees. That's not going to happen. But there are lots of ways that you can do community service that are consistent with your disability. So work with your probation officer. But we're going to get back together if it's been 6 months and you've done 0 hours of community service. In fact, I'm going to require that you have done at least 20 of those community service hours within the first 4 months of your probation to show me that you're moving along with that. Your primary source of income is government benefits. I'm going to waive your probation supervision fees then. I will set a behavioral incentive date of March 14th, 2030. So if you've done everything and not been a headache for probation, we can wrap up probation a little early. You'll be an old man by then, you'll be 50. And hopefully you're done with whatever kinds of things you were doing in this case, whatever got you in trouble in Griffin. And I'm going to remind you, you still have this open case in DeKalb. That's not going to affect your probation or anything, but you're going to need, because your probation is starting after that incident. But you're going to need to deal with that. Don't miss court for that. Missing court would be a reason for me to revoke your probation. All right? Home is going to be where for you? What county? All right. Ms. Rios, anything else on behalf of Mr. Rogers? Ms. Dilligard?
Nothing further, Judge.
Ms. Simpson works with probation. She's going to give you reporting instructions for probation. All right?
Oh, Mr. Rogers, what you would need to do is make sure to report to the Atlanta office within 48 hours from your release. The Atlanta office is going to be 276 Memorial Drive. That's about 5 minutes from this building. When you report in, they will give you further instructions on in regards to community service.
They just understood that I got to go other places to deal with some things before.
Oh, that's right. I forgot about that. So it's 48 hours, you said, after release?
Yeah.
Right. So they'll know when you're released. You are next going to go to Griffin to deal with whatever's going on down there. You may be released from Griffin. We don't put a hold on you to say, no, you got to come back and be released from Fulton. And so whenever you are out there breathing fresh air again, not in an Uber and not in a Lyft, you need to get to the probation office here, a couple blocks from here, within 48 hours of being released. Okay? So yes, it is understood that you got some more time inside because you got to get down to Griffin so they can sort that out. All right?
I wonder if they have taxi cabs
All right.
there. I don't know. So, okay. This next clip is only 10 minutes long. And it's just something we're going to watch. We're going to keep an eye on. So, there is a pro se defendant who is suing the police department in Connecticut. And this is one of the hearings because the lawyer for the police department wants the case dismissed because the pro se defendant didn't file some paperwork correctly. So we're going to watch this motion to dismiss right now. It's only 10 minutes long. But we're watching it because we're going to keep an eye on this. Apparently, they searched her house multiple times. And I don't know if they had warrants or not. I don't know. I don't know how strong this case is. I've read through the complaint, and I don't know. So we're going to watch it. We're going to keep recording these till we get to the end. And this is bootleg? Bootleg? I don't even know what that means. No.
Crystal Joseph versus Stamford Police Department.
Good morning, Your Honor. Crystal Joseph.
Good morning. Sorry to have to skip you, but I couldn't hear Attorney Lee. So hold on one second.
Okay,
How are we doing there, Attorney?
This is the pro se defendant, Crystal Joseph. This is Attorney Lee. He's the attorney for the police department.
Lee, hearing better?
I think it's better.
Yes, you're much better. All right. Great.
I apologize to the
No
court
worries.
and to Ms. Joseph for that.
I think we're doing okay now. So this is your motion for non-suit. And I have reviewed the papers. I understand your arguments. Is there anything that you want to put before the court today? I know that there was a request to revise, and that the complaint was revised once. And then you filed another request to revise, which was not revised or objected to. And I would say that the way the case law is going sort of right now, technically you're correct that it wasn't, but with a self-represented party, and I think that I think that your argument probably would be stronger if based upon the first request to revise that there was no response, but it's. The fact that there's another, I think can be a little confusing sometimes.
I don't want, my purpose of filing the motion for non-suit is just simply to get before the court. And
the motion for non-suit is a motion to dismiss the whole case because she didn't reply.
And
straighten out the pleadings.
Yeah. Right. And allow the court, because Ms. Joseph and I have talked, but she's not represented by counsel, so she's understandably, she's understandably, I guess, suspect when she's talking to a lawyer. I just want to be able to investigate the claims, and for that, I just need dates, locations, and clarifications of the pronouns. I think she uses they in a couple spots, which was it was difficult for me to figure out who she's talking about, whether or not it's the neighbor or the police, and the statutes that she's relying on.
So let me say this, Ms. Joseph. So whenever there's something like a request to revise, you have two options. You can revise your complaint, or you can object to the request to revise. But you can't not answer it, even if there's already been a request to revise. Once that's in there, you sort of have to respond one way or another. And in this case, you do have to respond to that request to revise because you didn't object to that request to revise. And so now counsel's looking for your case to be non-suited, which sometimes is something that the court can do when somebody's not responding. We can just say, okay, you don't have a cause of action. We're going to non-suit you. But I based upon and I'll hear from you in a minute, but I just wanted you to understand that I'm not inclined.
If I had a nickel for every time I was non-suited.
To non-suit you for this and dismiss your action because because you're a self-represented party, and it can be kind of confusing. Some of this procedure can be kind of confusing, and Attorney Lee is on the opposite side as you, so it's not going to necessarily be something that you want to follow his advice, right? So that's sort of where we're at. I'd like to give you an opportunity to revise your complaint, but I'll hear you this morning on anything that you want to bring before the court.
Yes, I was waiting for a court date so, the judge could decide whether I needed to revise or not. I had an issue with every time I did a revision, and then I went down to the clerk's office and I asked if, I needed to do another revision, and they said that I did not. They said that I could wait until the judge. I didn't know I had to file an objection. To revision. Yeah. So it can be kind of confusing, and that's where I think maybe the trouble started in terms of that you could have, they may have been trying to say to you, you could object to it, and then the judge can decide whether or not you have to do it. But technically, you either have to object or revise. So that's sort of where you're at. So at this point, what I'm going to do, and I think I did review the complaint as well as the request to revise. And I do find that there was not a timely objection to that request to revise. So that you do need to, it's going to be the court's order today that you need to revise the complaint. And the best way to do that is really read through that request to revise from Attorney Lee and see the things in there that they're saying, hey, listen, these things are missing. We can't really respond unless we have this information, and try to revise it in that respect. Okay? Yeah, I did a FOIL request for all of the incidents, the detailed reports. And basically, I was not given all the times and dates that the police officers unlawfully entered my home.
So what I would say to you is two things. One is that when we're at the pleading stage, some of that you're talking about is evidence that is going to be necessary sort of down the road. Okay. Right now, what you need to do is just sort of allege causes of action that then you could be getting discovery later on. So really just really look at that request to revise as to what they need in terms of allegations in there. And that'll sort of be a guide as to what they're saying that you need. Okay. That's number one. And number two, so a lot of times people that are self-represented are sort of availing themselves of FOIA requests and things of that nature in order to get information. And I'm not trying to discourage you from doing that. But what I'm saying to you is once that there's a cause of action, a lot of the information that you might be looking for may be something that you're getting in the course of what's called discovery. And so those are specific questions that you're posing to the opposite side saying, I need this information. And so that's where you'd be getting it from, not necessarily through a FOIA request. So I think you've been availing yourself of the law library and what you can ask for in terms of the discovery will be in those pleadings. They can tell you how to do that. Okay. All right. So you can go ahead and I'm going to deny the motion for non-suit. I'm going to put an order in that you need to respond to that request to revise, and you have about 30 days to do that. So you need to get that in as soon as you can. And then after that, you may be filing some discovery requests of the opposing side, and that may provide you with other necessary information you might need or want. Okay?
Okay. Thank you.
All right.
Yeah.
Do you have any other questions this morning?
No. Do you think Mr. Dana has the information that I need as far as the incidents, as far as the police? Because I didn't get them from the FOIL request.
So what I'm going to say to you is, first, I think you need to just deal with that request to revise first off.
Okay.
And secondly, you can file some discovery motions. There's two types of discovery. You could ask for, in writing, you ask for, these are the things that I want in discovery. And then, or you can take depositions potentially down the road. So first off, I would just respond to the request to revise, and then, look in terms of what discovery that you want to ask for. And you can always, I'm sure, have conversations with Attorney Lee in sort of a non-formal way if there's certain things that you can work out. Some things people can work out between the parties, and other things they need to come to the court for. Okay?
Okay, yeah, Anna.
All right. Is there...
Started on that provision.
Okay. All right. So, Attorney Lee, I'm going to put orders into that effect. Is there anything else that you wanted to put on the record today?
No, Your Honor. Thank you.
Okay. All right. Thank you both. You'll see my orders there, and you can check online. Thank you.
We have a court date on the 14th.
I don't.
It's about a scheduling order, Your Honor. It's a different issues.
Okay.
I'm open to any date that you have. I'm gonna get started on that revision, and hopefully I can turn it into you in the court, Mr. Lee, by the end of the week. Yeah. If not, definitely next week. I'll go back to the law library and
let me just say this one thing, Ms. Joseph. So, as part of these lawsuits, the parties are required to enter into sort of a cooperative scheduling order. And so they work out dates together, and then they put it in the court of what dates they think that the case is going to proceed. So I think you need to have some conversations with Attorney Lee, saying, seeing if you can work out some of these dates cooperatively. And then I'm sure that he will put an order in, a proposed scheduling order that represents what you both have sort of decided to do, and he can enter that, I'm sure, as a pleading in the case. Okay.
Okay. Thank you so much.
That's something else that you can do. But I would encourage communication.
No, don't communicate with him. It's a trick.
There's some things that you kind of have to talk to each other about. Other things the court can get involved in, but that's something that usually the parties work out together.
Okay.
Okay. All right. Thank you.
Have a good one, Anna.
You too. Thank you. Okay, I believe that's all we have.
All right, we're going to keep an eye on her. We're going to keep an eye on her for when she gets to her real trial, and see how it goes. I want to hear her question the police that come into her home. I have such a long manual on how to be a mod. You have no idea. It's a secret, though. Okay. We do not have a verdict or an answer in this next one. It's just an interesting argument. Because in my head it's absolutely clear. I mean, in my head, I don't understand why they're even arguing. I really don't. But they don't come up with an answer because the judge has to research more because they don't know the answer. Which is just silly. It's silly. But yeah, we're gonna watch lawyers and judges try to figure something out.
I'm gonna give Ms. Douglas, who appears in person. All right. And we have a number of motions that have been filed here, but there's really two motions that require testimony. And one of them is the motion for a jury instruction to suppress testimony or a jury instruction regarding misuse of body-worn camera. And quite frankly, I need to hear from the officer to describe what happened before I could possibly understand whether or not I could make a finding that that officer was required to click on the dash cam or not. And then, of course, a motion to suppress for lack of reasonable suspicion. And before I hear testimony on the motion to suppress for lack of reasonable suspicion, I just wanted to clarify. Just because the defendant or there is no dash cam video doesn't mean that there can't be reasonable suspicion to pull someone over.
So what these two motions together, what defense's contention is that if there was dash camera and it should have been activated, then that statute suppresses any testimony
at any hearing.
At any hearing,
Okay.
including at a motions hearing in which if reasonable suspicion is raised,
Okay.
then the officer would not be able to testify to any reasons for pulling over Mr. Douglas. And so then there would not be reasonable suspicion.
I just wanted to make sure that you weren't asserting that seeing someone swerve, for example, must be seen on dash cam in order for it to qualify as reasonable suspicion. I understand the distinction as you're saying if they were required to turn on their dash cam and they didn't, then it should be suppressed. I can't consider it. I understand that's your argument, but I want to make sure you're not arguing that you have to have something memorialized in that sense to deem it to be reasonable suspicion.
If the officer is allowed and not prevented by the body camera statute from testifying that he saw Mr. Douglas swerving, then we, agree that there would be the court could find reasonable suspicion.
Okay, then before we bring the officer in here, I just want to be clear. So really, what we're talking about in both motions is about
if there was dash cam
2431 902, the existence of the dash cam and when it was turned on or not, and what circumstances took place surrounding that dash cam. So that's really what we're talking about right now.
Yes.
Okay. I just wanted to make sure we weren't going to have an argument about whether or not if you saw someone speeding but it wasn't memorialized, that necessarily means there's not reasonable suspicion. If that's not what you're arguing, that's fine when you evade your officer.
Yep.
And Ms. Pretz, are you also on this case?
I am, Your Honor.
Okay. Trooper, what's your last name? Mr. Trooper Hilliard, I'm going to ask you to approach this witness stand. Sure. And before you sit down, face me and raise your right hand. Do you solemnly swear or affirm under penalty of perjury of law that the testimony and the information you're about to provide this court is going to be the truth, the whole truth, and nothing but the truth? Yes, sir. All right, please have a seat. And what you can do once you scoot your chair in is you can pull this microphone a little closer to you. You can bend it as needed. All right, once you are comfortable, Ms. Grout, this is your witness.
Thank you. Good morning. Please state your name, spelling last for the record.
Trooper Michael Hilliard, Hilliard.
And where are you currently employed?
Colorado State Patrol.
And what is your title?
Trooper.
And how long have you been a trooper with Colorado State Patrol for?
About 3.5 years.
And what is your general role day to day at Colorado State Patrol?
Used to be just patrol, responding to crashes, enforcing traffic laws, those types of things.
And were you working on the day of December 22nd, 2023?
Yes, ma'am.
Where were you working?
Westbound Highway 36.
And is that in Boulder County, Colorado?
Yes.
Thank you. And did you have your body camera turned on that day?
This is Judge Smelkinson. So, apparently a while ago, a couple months ago, I had a pro se or a soft sit well, a pro se sov sit from his courtroom. And he was supposed to come back sometime recently. And I've been trying to get Judge Wilkinson every day to see if that sov sit will come back. Was it Kurt? I think Kurt reminded me. And someone else reminded me that they were supposed to remind me, but they didn't know what they were supposed to remind me. So I actually got 2 reminders to get this sov sit, and I've been trying. This is Judge Wilkinson's docket, and there was no sov sit on here. So maybe it was continued. I don't know.
Yes.
And do you know if your body camera recorded the incident? Or let me back up. Do you remember an incident with a sedan weaving?
Yes, ma'am.
And do you know if your body camera was turned on during that?
During my interaction?
Yes.
Yes.
Wait. That's not responsive. You asked about weaving.
I was just referencing the incident. Was your body camera turned on while you were responding to the incident of the weaving?
Yes.
Okay. And when you were responding to the incident of the weaving, were you on patrol?
Yes.
And did you have any dash camera turned on during this incident?
No.
And why is that?
The vehicle that I was using at the time, we were in the middle of switching out our L3 system to the Axon system. Due to the amount of miles that were on that patrol car, they didn't install an Axon camera, and the L3 camera was disconnected, deactivated.
So does that mean it was not possible to have dash camera on December 22nd, 2023?
That's correct.
And I know you're going to get more questions from the attorney about this. So you call it L3?
That was our the original system that was in the vehicle.
And and the Colorado State Patrol was upgrading to a different system, and that L3 system was unplugged or not working?
Yeah, so the camera itself and the L3 system itself was completely disconnected.
Okay.
And because the system was disconnected, was there any fleet camera?
No.
And you mentioned the Axon. Is that the current system that Colorado State Patrol uses for dash camera and fleet camera?
Yes.
And was that installed on December 22nd, 2023?
No.
So was there any possible way for you to record any incident on either dash camera or fleet camera on December 22nd, 2023?
No.
So because of that, were you able to capture any video of the sedan weaving?
No.
Okay. No further questions.
I do have a question. So what'd you see?
So I saw the sedan originally weave onto or over the first double white solid line into the HOV lane. Straddled it there for maybe a couple seconds, went back to the left lane. I observed the sedan weave another 2 times over that first solid white line, where I was able to clearly see it underneath the vehicle.
Underneath the vehicle?
Yeah, so past the driver's side
I
tires.
understood. Okay. And then what happened?
From there, I initiated a traffic stop and contacted Mr. Douglas.
When did you turn on your body-worn camera?
Body-worn camera was turned on as I was exiting my vehicle, getting ready to contact Mr. Douglas.
Okay. And then between, and I'm asking these questions because I really want to get to the bottom of everything that could happen at a trial. Between your decision to stop Mr. Douglas for the alleged weaving and your exiting the body-worn camera, were there any other observations you made regarding driving behavior?
No, it was just weaving.
Okay, thank you. Cross-examination, Mr. Solomon.
Yes, Judge. Hi, Trooper. So the first time you saw him weave into the HOV lane, then you began following Mr. Douglas,
Yes,
and you followed him for a mile.
approximately. Yeah,
And in that mile, that's when you saw him weave twice more.
correct.
And your body worn camera wasn't activated during that mile that you followed him on the highway.
No.
It wouldn't have captured any of the driving.
Correct. It would have just captured a steering wheel.
Okay. Typically, do state patrol vehicles have a fleet camera, both with dash cam and showing the backseat of the patrol car?
Usually, yes.
Okay. So before the date when this happened, most of the time you had one?
Correct.
And there was this switch over from the L3 system to the Axon system going on in the fall of 2023. Is that right?
That sounds right. Yes.
And I think you testified that it was because of the age and the mileage of the vehicle that, and you said a couple times disconnected. Was the actual hardware of the dash cam still in this vehicle?
Honestly, I don't remember if the camera was in there. I know the like little computer system that we use to like actually activate the camera if we weren't activating it with lights was still in the vehicle, as well as the microphone. But the camera itself, I don't believe it was, but I'm not sure.
Okay. With a lot of these systems with L3 and Axon, they sort of have, the cloud storage for all this data. Was that what was turned off with the L3 system?
Yeah, so I guess our contract with L3 was just completely done. Like the system itself was no longer in use for us.
So without that contract with L3, even if the camera was in the vehicle, you couldn't do anything to record with it?
Correct.
If you had pressed record, what would have happened?
And I don't remember if the camera was actually in there, but I don't believe anything would happen just because everything was disconnected.
About how often, if you're able to estimate, are you in a car that doesn't have dash camera and rear seat camera?
Very rare. It was just this one, well, the few months that I had the vehicle during this transition that I didn't have the camera.
And was this unique to just this one vehicle? How many vehicles in State Patrol were in this state during this time?
I don't know for sure the exact amount of vehicles that were in the same predicament as mine. I know at one point I did have to switch to another car that was in the same position while mine was getting maintenance. So I can at least say definitely two.
But it's an unusual thing for a State Patrol vehicle to not have these cameras.
Correct.
Can you talk to me just a little bit about why it's important for all of the State Patrol vehicles to have dash camera and rear seat camera?
To record and show exactly what it is that one we're seeing, and then to also make sure that nothing odd or unusual is kind of going on in the back seat type.
I have no further questions.
All right. Do you have any follow-up?
No.
Trooper, you're all done. Thank you.
Thank you.
Do you have any other witnesses?
No, we do not.
And Mr. Sullivan, any other witnesses?
No, Judge.
Okay. And to both of you, thank you for focusing this on these issues. And now having heard this, I understand the precision of the issue. So I appreciate that. I guess since this is your motion, Mr. Sullivan, why don't you go first?
Judge, based on the testimony we've heard today, this is an unusual situation for the State Patrol for them to not have these cameras. That's why we filed these motions and why we're having this testimony today.
Did they? Are you sure? Because they're all really confused what to do now because there was no dash cam.
Is because it's sort of expected that the State Patrol, as the state's law enforcement arm, would be up to date with this. State Patrol had dash cameras, fleet camera, prior to the body-worn camera statute. They were early adopters of that. They also very quickly changed over to body-worn cameras when those were required. The officer testified today that there was a fleet camera physically installed in the car, but that due to a lack of a contract with L3, recording was not possible. I think what the court must decide today is whether the statute, when it says if the peace officer's vehicle is equipped with a dash camera, that it shall be activated during that time.
So let me direct you to 24-31-902, 1A3, and specifically notwithstanding any other provision of this law, this subsection does not apply if the body-worn camera was not activated due to the malfunction of the body-worn camera and the peace officer was not aware of the malfunction or was unable to rectify it prior to the incident, provided that the law enforcement agency's documentation showed the peace officer checked the functionality.
And Judge, I'd say that
is this in that category?
I don't think so, Judge. I don't think this is a malfunction. I think that what that part of the statute is contemplating is if a police officer does everything right, hits the button to start recording, and it's a broken body-worn camera and it doesn't record, that an officer isn't punished for doing what he's supposed to in that situation. What we have here is the State Patrol sending a trooper out in the vehicle that's available to him, but in a vehicle that they know has a fleet camera which is unable to record. This isn't a malfunction as in something that is they're unaware of or that's unexpected. This is sending out, a law enforcement officer into our community with an inability to record what's happening to people that are in the back of his car, as well as not recording what's happening in front of him. I think specifically the testimony he gave today, as far as following Mr. Douglas for a mile on the highway, if he had fleet camera, that's plenty of time for him to activate it. This wasn't a brief traffic thing that he witnessed and then had to pull over Mr. Douglas. There was, I would call it a traffic investigation from following him for that period of time. I would say that it's up to the court to determine whether when in 24-31-902, 1-2A, I believe, 1A, 2A, the question is whether this vehicle was equipped with a dash camera. And the testimony today is that it was equipped with a dash camera. It's just that there wasn't a contract that made that dash camera usable. So that's, if you had bought a dash cam or it was still in the box, or you set it up but you haven't plugged it in, is that a dash camera? If it's not working, it's not a dash camera. Judge,
it's a piece of metal.
If Trooper Hilliard had not, if Trooper Hilliard had not charged the batteries in his body-worn camera, then it'd be a similar situation. It's for a different reason. But in that situation, if Trooper Hilliard had not, I don't know if these are rechargeable batteries or they take AAAs, but if he had not, if the batteries were not there and he knew and he went out to go on patrol that day, knowing that his body-worn camera was out of battery and could not record anything.
No, but that's different. That's because the difference is in that situation, that would be user error, very possibly on the shoulders of Trooper Hilliard. Here, there's nothing Trooper Hilliard could have done to turn on this camera.
No,
that's what I mean. I
agree with that.
It's a shell of a camera versus what you're talking about, which is, I forgot to recharge it and turn on the equipment properly, which would potentially fall on the shoulders of Hilliard for negligence in that hypothetical.
No,
here we just have some plastic or metal apparatus that doesn't matter if you plug it in or not because it's not going to do anything.
Yes, and that's nothing that Trooper Hilliard could have done, but that's something that the State Patrol could have done by not sending out a trooper in a vehicle in which it's not recording these things that they've recorded before and they've recorded since. And of course, there are logistical limitations on what our law enforcement agencies can do.
Are you in court right now? Which county? I will record it. If you give me the details, I will record it. I will record it. But there's no way you're in court right now because you're in Colorado. And it's like 4 a.m.? So this must mean that they showed up yesterday. Which means I didn't know. Yesterday was Saturday. I don't know.
But at the end of the day, it's Mr. Douglas whose rights are impacted by this, and that he's being prosecuted for a traffic violation that would have been caught on fleet camera in almost any other situation by a state patrol trooper. And it's only because the state patrol, for whatever reason, sent Trooper Hilliard out in a car that they deemed was too old to upgrade, seems to be the implication with the new system, and to not keep up the contract with the old system. So ultimately, while Trooper Hilliard, there's nothing he could do in that moment when he gets behind Mr. Douglas, it is still on the law enforcement agency to comply with this statute. And I don't believe that they've complied with the spirit of the statute. And I believe that if the court reads the sentence that I've read a couple of times about being equipped with a dash camera, that they are in violation of the express terms of the statute as well.
Yeah.
And while I understand that this may be a remedy, I understand that the court may be considering that if my motion is granted, that ultimately this may lead to the dismissal of the charges against Mr. Douglas if there's no reasonable suspicion for the traffic stop. And that may be a drastic, situation in where I don't think that the court can find that Trooper Hilliard personally did anything wrong in the circumstance he was in. But this statute is meant to protect the public. It's meant to protect people like Mr. Douglas who interact with law enforcement officers. And what our state legislature has said, that it's important for us to get these things on camera because it's feasible, it's affordable, and it's efficient for us to capture these things on camera. And in this situation, the State Patrol chose not to give Trooper Hilliard the ability to comply with that statute that day.
No, I mean, I agree with everything you're saying. And if the remedy ends up being dismissal, the remedy ends up being dismissal. That's just what happens. And I don't want to get too much into the language, but I think we have to. And I want to hear from the people. You say the patrol car is equipped with a dash cam. It's not. Because equipped with a dash cam presumes that there's a dash cam that's working. And then if it's working, then we're back to the other thing. Did it malfunction because the officer did nothing wrong, or did they not check their batteries and charge it properly, in which case they did something wrong? So, you have a functioning piece of dash cam, functioning body worn camera, and then depending on the officer's use of that, the statute may exclude the evidence, and it may include the evidence depending on the officer's participation. My concern is, my concern with your argument is that just because there's some shell of this dash cam video, I don't know if I can call this equipped with dash cam. The question I have for the people is this. Not all law enforcement agencies in Colorado have body-worn camera or have dash camera. That's just a fact. And I don't believe all law enforcement agencies in Colorado are required to have dash cam or body-worn camera. My question to you is, in addition to responding to Mr. Sullivan's argument, is this interruption of functionality due to the contract negotiations CSP had, does this fall in favor of Trooper Hilliard, or does this fall in favor of Mr. Douglas, whom, by Mr. Sullivan saying, if it was a month prior, there would have been dash cam video. If it was a month after, there would have been dash cam video. CSP chooses to upgrade their system. They don't remove these cars from use on patrol during that period of time. And should they take this stuff out of patrol if it's essentially non-functioning? So that's what I want to hear, Ms. Grubb.
Yes, Your Honor. To start out, Section 2431.902 only requires that by July 1st, 2023, that all the state and Colorado State Patrol shall provide body-worn cameras for each peace officer. Nothing in the statute requires there to even have dash or fleet camera. So I think that that first is an important function, is this whole statute relates to the suppression of the body worn camera. And Section A does say if peace officer's vehicle is equipped with dash camera. But like the court,
And it also uses the word dash cam a number of times in this section. I mean,
that is true, but nothing in the statute requires dash cam or fleet camera. It only requires that there be body worn camera. Now, if the agencies choose to voluntarily have the dash and fleet camera, then that must be turned on. But nothing in the statute requires these agencies to have that.
well, I understand that, but I also want to push back a little bit here. If you look at subsection 3, it says if you fail to activate body worn camera or dash camera as required, then there's certain remedies.
If they do have that, that is correct.
Okay, so but I want to be clear because the remedy isn't just for body worn camera. The remedy is also for dash camera.
That is correct.
Okay,
Yes,
go
I
ahead.
was just making a note, kind of starting out.
That's fine.
And then as the court did mention, in the section that the court mentioned about the malfunctionality of the body worn camera, that this would not apply if it was malfunctioning due to certain different provisions, that the officer was not aware of the malfunction, was not able to rectify it prior to the incident. In this case, the officer would not have been able to rectify this in any way. The system would not have been able to push the video start, given that there was not a function to be able to do so. If the officer would have pushed record, nothing would have happened, given that there was a system transitioning from the L3 to the axon. Given that he wasn't able to rectify any of that, this statute is aimed at preventing transparency if there is a camera to make sure that it is turned on. And in this case, that nothing would have happened. So to answer the court's question directly about if this should be cited in front of Officer Hillard or in front of Mr. Douglas's favor, the people would argue that it would be in front of the people's favor. This statute is to create transparency when there is working camera. And if the legislation did not want to provide that provision, a blanket statement saying, nope, it doesn't matter if there isn't a camera working. If the camera is not recorded for whatever reason, then it's suppressed. The legislation would have said that, but they clearly made the carve out saying if the officer was not aware of the malfunction or is not able to rectify it. Given that they have this provision, an officer or Trooper Hillard would not have been able to rectify it, the people believe that it must be in favor of the people, given that there is nothing that the officer could have done if he would have pushed play on that day.
Well, then let me ask you this. Because we're talking about transparency here, and it doesn't sound like there's no evidence suggested from the defendant, and nothing that I intuited from listening to Trooper Hilliard that this switching from a L3 system to an Axon system was done to evade transparency. But is there a responsibility of law enforcement if you are going to upgrade your cameras, do work on a vehicle, switch to a new system, do any sort of maintenance of these dash cam or body worn camera systems? Is there any responsibility for law enforcement to make sure that their fleet cars have functioning cameras just because they happen to be malfunctioning, or I'm sorry, upgrading? For 30 days or whatever period of time, it's unclear. Trooper Hilliard didn't have functioning dash cam. Is there any responsibility on the state patrol to do something about that?
And yes, people believe that it would be beneficial, but that's not what the statute requires. In this case, Trooper Hillard had his body worn camera on before he approached. He did everything right with that. And the statute nowhere makes it that they have to put on the fleet camera or have to put on any dash camera if they don't have it. So while it would be beneficial, given that the legislation has only mandated since July 2023 that body worn can't have the camera be working, and they have not made it that dash camera or fleet camera has to be necessity, Colorado State Patrol was actually going above and beyond of what the statute requires, given they didn't have to have any of it. So while they maybe should have had some repair during that time or done something, they did have the officer still wear his body worn camera, which he was necessarily had to wear. And they were working on upgrading their system to try to be better than the statute even requires them to be, because they didn't even have to have any fleet camera or any camera inside their car. So maybe they should have had a system in place. They did what was necessary by having the body worn camera on, and nothing in the statute requires that.
So your argument is if you start doing dash cam as a law enforcement agency, we have a bunch in this jurisdiction. If that law enforcement agency starts doing dash cam and then puts a pause on that program, they can just put a pause on that program and then reinstate it. I guess that's what I'm trying to figure out, because you're saying, hey, this is great. They're not obligated to do dash cam, but you've conceded that if they do have dash cam, it must be recorded.
Yes. And that is correct. However, I do think in this situation, it falls under that statute that the officer could not have rectified it.
Okay.
So I think that there is a carve out in this specific case that the officer could not have rectified it in that case.
Got it. Thank you. Mr. Scott, you brought the motion. You get the last word. Anything you want to say?
Oh,
I'm sorry, Sullivan.
that's fine. I would just reiterate that it's our contention that it was equipped with a dash camera. That while it was not in a condition, because
It's okay. Just give it 1 second. Everything's fine.
people did not maintain it in a way, and I don't think this is a malfunction. I think malfunction necessarily means something that is out of their control. It's necessarily something that was not caused by the police officer or by the law enforcement agency. In this situation, the reason that the fleet camera was unable to record was because Colorado State Patrol was in the midst of was no longer in contract with L3. That's not a malfunction. I don't think that entire section of the statute applies to the facts before the court today. I think the only question before the court is whether, per the statute, and I'm not aware of any case law that would inform the court on how to decide this.
As of 3 months ago, there's no case law on this issue.
I would say that the court should rule that Trooper Hilliard's car was equipped with a dash camera, that by no fault of Trooper Hilliard, it did not record, but by fault of the Colorado State Patrol, it was not functional. It was not malfunctioning, but it was not functional on that day. And because of that, Mr. Douglas is entitled to the protections of this statute.
I understand. And I think your argument in part, you're certainly relying on the plain meaning of the statute, but also you're saying equipped means there's something attached, and you're saying malfunction does not mean they're upgrading their system, correct?
Correct.
Okay. Mr. Douglas, I don't want to delay this too much, but I really want to think about this. It's an unusual issue. And what Mr. Sullivan and I were just referring to is there's no case law on this. So many of the legal issues that come in front of the court, I don't know if you have any experience with the criminal justice system, so I hope I'm not talking to you in a way that you already understand. It's based on these cases and these laws. And there's these laws and these cases that explain the laws and tell me how to interpret them, and parties argue how I should interpret them. This is an unusual statute and law from Colorado because it's relatively new. And as far as I know, there's not a lot of cases that have analyzed this and tell me this is how you should think about the word malfunction. This is how you should think about the word equipped. This is how you should think about this law. So unfortunately, in your specific situation, I just don't have a lot of guidance, which I normally have when I'm making a legal decision that the parties want me to make. Because I don't have a lot of guidance right now, I want to take a further look at this and see if there's anything I can come up with that will help me determine if I should go along with what your attorney, analyze this the way your attorney wants me to analyze it, or analyze it the way the people want me to analyze it.
Let me just say it a little different. So, the trooper visually sees a car swerving all over the road and pulls him over and gives him a traffic citation, and that's why we're here. They're saying, well, the dash cam didn't pick it up, and the dash cam is supposed to. The law doesn't say that. The law says they have to wear a body camera. And he was wearing a body camera, and he turned it on when he got out of the car, and he has the whole thing on body cam. He just doesn't have the swerving on dash cam. Okay? Right. Now, let's think about it in a slightly different way. Let's say instead of the officer seeing the car swerving across the road, the officer visually sees him shooting someone in the car and killing them. The officer watches this happen. The officer watches him shoot the passenger and kill the passenger, and then pulls him over and charges him with murder. Do we still think that, oh, he shouldn't be charged with murder because there was no dash cam?
It's just an unusual statute because it's so new. I don't have much guidance from other courts. Does that make sense? So, let me just look at dates here.
And
so the pretrial readiness conference is on the.
He's not going to give an answer. He has to research law. They both have to submit a written something, I don't know, about their side of this, and give their own case law of what they think matters, and then he's setting a date right now for the next trial, which I won't get. I won't. I just thought it was interesting that we went through this, but I'm not interested enough to get the trial. No, we did this one enough. Yeah, we did things really well before technology. When I'm a server and when the POSs go down, everybody around me is like, "Oh my God, what are we gonna do?" This is what you do. You just write it down and you hand it to the kitchen. It's really easy. Hamburger, kitchen. Yeah, the cops saw this person committing a traffic violation. So the cop pulled this person over and gave him a ticket. That's pretty much their whole job, is to see traffic violations and give out tickets. Well, two quick things. No OJ today. I can't do OJ on the weekends when I'm working doubles. I can't. It's too much for me. It really is. And thing number two, we did not, in fact, get 1,000 memberships this stream. So nothing. I can't take nothing off my to-do list. Nope, those are the rules. I'm going to have to sleep on Monday instead. Oh, y'all let me down. You all did me dirty. You were supposed to help me. But no. JK tried so hard. Me and JK, we tried to hit the goal. Guys, thank you so much for coming out. I really appreciate it. I really do. Yeah. Thank you to the new people coming in chat today. Thank you for coming in. I appreciate it. Another Smith. Bye, another Smith. Oh, I hate when another Smith misses out. You should have been around for the case in Arizona. Another Smith with the background. It was epic. All right. Yeah, but you would have to do it 1,000 times, Crystal. And nope, the stream is over. It's too late. Oh well. Oh man, I'm gonna have to sleep on Monday. Poor me. I hope you guys have a great Sunday or Monday. And I will see you all. I work a double, so I won't see you all today, but I'll see you all again soon. Bye, guys. Thank you.
Sean. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her cue, a dark and twisted charm. In a way, there's no alarm. Screaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray,